And a good Saturday afternoon, everybody. How you doing? Welcome to this edition of Bethea'S Byte Reloaded. I'm Ernest Bethea, the last Outlaw. So good to see you all. And honestly, today I'm in a somewhat somber mood, and I'll get to the reason why near the end of this edition. But we've got so much, and I do mean so much to cover. The only thing I'm grateful for is that I do not have an updated missing persons case to follow up on. So what I'm gonna do is get this underway. I'm gonna start off with a number of updates on cases that you might be following. I might personally not be following, but there are those cases, and we're gonna just go ahead and dive right in. All right, the first case I want to open up with is Alex Murdaugh. I know you guys are following that one ever since he was convicted of murdering. Ever since he was convicted of murder, but I've got a brand new update for you because as of yesterday, he pled guilty to financial crimes, which means he's already going to be tacked on another 27 years into his double life sentence on the murder conviction. This is the details as I'm going to share them with you right now. This is coming out of Beaufort County, South Carolina. And, all stories that I'm bringing to you, unless I'd say otherwise, is coming courtesy of my good friends at Court TV, your front row seat to justice. Convicted killer Alex Murdaugh is pleaded guilty to dozens of financial crimes spanning several counties in a global plea deal reached 2 weeks before his first trial was set to begin. Disgraced former attorney Murdaugh was convicted by a jury in March 2023 of killing his wife and son and was sentenced by Judge Clifton Newman to 2 life sentences. Murdaugh has maintained his innocence as he appeals his sentence and asks for a new trial. Friday's hearing was intended to be a change of venue motion hearing, where defense attorneys were expected to argue relocation of the first of Murdaugh's state-level financial crimes trials, set to begin November 27th. Regarding the estate of Gloria Satterfield, the Murdaugh family's longtime housekeeper. Alex Murdaugh, who was handcuffed and wearing a bright orange SCDC jumpsuit, was escorted into the Beaufort County courtroom to join with his attorney, Jim Griffin. Judge Clifton Newman took the bench unexpectedly, announcing private matters that the parties needed to discuss. He recessed the court, and Murdaugh and the attorneys left the courtroom, presumably to Judge Newman's chambers, where sources told Court TV plea deal negotiations had begun. 3 hours later, the parties reconvened in the courtroom, where Prosecutor Creighton Waters outlined the details of the plea deal that would add 27 years to Murdaugh's double crime conviction sentence, which is an 85% reduced sentence had a jury found him guilty of the crimes. Judge Newman then turned to Murdaugh directly for his plea. Judge Newman asked him, "Do you wish to withdraw your not guilty plea and plead guilty?" Murdaugh responded, "I do." Judge Newman, "Is there any question in your mind about the proceeding?" Murdaugh, "No question in my mind." Judge Newman, "Have you had enough time to think about it?" Murdaugh, "Yes, sir. I've had a long time to think about it." Prosecutor Waters once again walked the court through the financial crimes victims, many of whom were discussed at length at Murdaugh's murder trial, including Natasha Thomas, Chris Wilson, the Satterfield family, and even Murdaugh's own brother, Randy Murdaugh. Murdaugh was indicted on more than 100 charges in South Carolina for financial crimes spanning several counties. The indictments obtained by Court TV indicate that Murdaugh was facing charges for financial crimes in Allendale, Beaufort, Colleton, Hampton, and Orangeburg County in South Carolina. Murdaugh pled guilty in a federal court in September on a number of charges, including bank fraud, wire fraud, and money laundering. A sentencing hearing has been set for 10 o'clock a.m., November 28th. Now, friends, all I know is this. If you're willing to go through all of this just to protect your neck on a lot of everything else you're doing, and you're gonna come out right then at this point and declare yourself guilty, that might be the smartest move you'll ever make, because taking your chances in court, let's see, 27 years, which is 85% reduced. Had he been found guilty in a jury trial, yeah, say the odds would not be in your favor. Okay, that takes care of Alex Murdaugh, but I'll give you the details when the time comes for his sentencing. My goodness, I had so much to work with. Hold tight, guys, or as my good friend Brittany from Allegedly with Brittany J would say, hold please. There we go. All right. All right, one for the Justice Surf file, ladies and gentlemen. All right, has anybody been following the case of the two boys, and I say boys for a reason, who were accused and ultimately pled guilty for beating up their Spanish teacher, all because one got a bad grade? Yeah, I mean, sure, the logic is nowhere near sane, but this is what happened. And an Iowa teen is facing sentencing after he and his friend admitted to killing a hike. Oh wait, I'm jumping behind because I might as well go and give you the whole thing. Iowa teen facing sentencing after he and his friend admitted to killing a high school Spanish teacher in separate plea deals. Jeremy Goodale was only 16 when he and his friend Willard Chaden Miller ambushed and fatally beat Nohema Graber to death on November 2nd, 2021. And as you can see here, if I have showed it to you, I will. All right. On your left is Willard Miller. On your right is Jeremy Goodale. The two former Fairfield High School students learned they would be tried as adults after a May ruling by the judge to reject individual offers to move their cases to juvenile court. Days before jury selection, Miller pleaded guilty to first-degree murder, and he was sentenced to 35 years, 5 years more than prosecutors had asked for. Goodale, now 18, who was expected to testify against Miller at trial, also pled guilty to first-degree murder in a separate plea agreement. Both teens confessed to a plot to ambush Graber while she was taking her daily walk, beat her to death with a baseball bat, and then hide her body, but have conflicting statements about who did the physical beating. This was the Spanish teacher, ladies and gentlemen. At Miller's change of plea hearing in April, Miller admitted he had stood lookout in the park, while Goodale fatally beat the 66-year-old Spanish teacher who gave Miller a failing grade and hurt his chance to study abroad. Miller even denied striking Graber. Goodale, on the other hand, contends Chaden brought the bat and other supplies, and that he was the one posted as lookout while Chaden hit Graber in the back of the head with the bat. Then both boys moved her off the trail where Goodale says he made the final fatal blow. The disappearance of the 66-year-old married mother of 3 and active church members sparked a community-wide search that led her to her battered body under a wheelbarrow in a Fairfield Park where she took daily walks. At Miller's sentencing hearing in Jefferson County Circuit Court, Judge Sean Showers, tongue-tied. Judge Sean Showers said the teenager's decision to spare the community a trial with a guilty plea weighed in his favor. Nevertheless, the judge went above the prosecutor's recommendation, saying the cold-blooded, premeditated nature of Graber's death and its impact on her family and the community called for a lengthy minimum sentence of 35 years, even though juveniles in Iowa are not required to serve mandatory minimum sentences. At Goodale's sentencing hearing, Goodale's sentencing hearing was scheduled for November 14th through 15th, when prosecutors are expected to recommend a sentence of 25 years to life with the possibility of parole. Yeah, so that young man may have lucked out at that point. He may have lucked out at that point, but that was until he was sentenced. Oh, please. All right. Okay. What you're about to see here is the full on sentencing video for Jeremy Goodale, and if I can, let me go ahead and I definitely need to pull this up because this is definitely needed. All right, there we go. There's your copyright disclaimer. And now the sentencing of Jeremy Goodale.
The threat of safety to the public or individual posed by the defendant, Again, I think this is an aggravating factor, as any individual, regardless of age, who could be persuaded by another classmate to kill his teacher is a danger to the community and will require significant rehabilitation. The degree of participation in the murder by you, Mr. Goodale, is the next factor. And I find that you knowingly participated in the murder of Naheema Brammer, and by your own admissions, hit the victim with a baseball bat 5 times using lethal force. While Mr. Miller concocted the plan, without your help, the execution of that plan would not have occurred. So I find this as an aggravating factor, and I don't think you have the same culpability as Mr. Miller. I think it's less, but still, without your help, he couldn't have done it. The nature of the offense is heinous, as you can imagine. It's a significant aggravating factor. Ms. Graber was killed in a brutal fashion by 2 of her own students. This murder requires the defendant serve a prison sentence for deterrence of the entire community, not just the defendant. And for context, I think it's important to distinguish some of the facts from this case involving you and Willard Miller to Miller versus Alabama, which is the U.S. Supreme Court case that Dr. Cunningham is brought in to testify about, and what we've had this last 2 days of hearing. The reason for the individualized Miller sentencing hearing is because while juveniles are different than adults, each juvenile and his or her acts are inherently different. So I don't think, I am not comparing you just to a lump of defendants that have had Miller hearings. Miller versus Alabama involved a 14-year-old defendant who assisted another juvenile in a robbery that resulted in a shooting. The defendant in Miller versus Alabama did not fire a gun or swing a bat. In a 6-3 decision, the United States Supreme Court found that the 8th Amendment ban on cruel and unusual punishment prevented automatic life without parole sentences for juvenile offenders. That's why we're having this hearing. And subsequent 4-3 Iowa Supreme Court cases went further to take away the district court's ability to sentence a murderer under 18 to life without parole. So in spite of the mitigating factors presented by your defense through Dr. Cunningham, other testimony, and presentation of evidence and argument, the court finds a prison sentence and a mandatory minimum is required for deterrence for the defendant and others from committing murder in the first degree. As U.S. Supreme Court Chief Justice Roberts wrote in his Miller dissent, our 8th Amendment cases have also said that we should take guidance from evolving standards of decency that mark the progress of a maturing society. Mercy toward the guilty can be a form of decency, and a maturing society may abandon harsh punishments that it comes to view as unnecessary or unjust. But decency is not the same as leniency. A decent society protects the innocent from violence. A mature society may determine that this requires removing those guilty of the most heinous murders from its midst, both as protection for its other members and as a concrete expression of its standards of decency. As judges, we have no basis for deciding that progress toward greater decency can move only in the direction of easing sanctions of the guilty. With respect to your remorse, Mr. Goodale, and unlike your co-defendant, it's clear to me that you have regretted this role in Ms. Graber's murder. You've been remorseful for these proceedings, and this is a mitigating factor. Factor G is your acceptance of responsibility. This is another mitigating factor, Mr. Goodale. You pled guilty to first-degree murder and acknowledged your actions. While you certainly have the right to exercise your constitutional rights to trial, to a jury, in a different place, like Mr. Miller, by pleading guilty, you spared the defendant's family, witnesses, and community a traumatic trial. And while these Miller sentencings itself are emotionally draining for all involved, and I doubt either Supreme Court's spent much time thinking about that toll before ordering us to do hundreds of these hearings. The U.S. Supreme Court requires them. You're entitled to it. And I certainly am required to do my job, and your attorneys have done their job very well in presenting evidence. Regarding the severity of the offense, which is factor H, including any of the following: the commission of the murder while participating in another felony, a number of victims, and the heinous, brutal, cruel matter of murder, including whether the murder was the result of torture. I mentioned the offense is usually heinous and cruel by stalking Ms. Cooper and repeatedly hitting her with a bat. Again, I'm required to find that aggravating as a factor. There's one murder victim here, but many have felt the lasting effects, including yourself, of your actions and Mr. Miller's actions. Regarding your capacity to appreciate the criminality of your conduct, I am required, and I do consider your mature and developing brain in this sentencing hearing, required by the U.S. Supreme Court and the Iowa Supreme Court. The defendant agreed to participate in the plan Mr. Miller and Mr. Goodale did to kill Nohema Graber, and this willful and premeditated murder is what resulted. You were 16 years old, and the law treats you as an adult for the purposes of prosecution, but as not as an adult for sentencing. And you have expressed genuine remorse that I did not see from your co-defendant. And this factor and the capacity to appreciate the criminality of your conduct, I think, is a mitigating factor. You stated that you never thought about the consequences. And I believe you when you say that, when you agreed to help Willard Miller kill Miss Nohema Graber. The next factor is whether the ability to conform with the defendant's conduct with the requirements of law was substantially impaired. And you didn't have any prior referrals to juvenile court services. And certainly your mother's abandoning you and your family at a young age could have resulted in youthful misbehavior. It's not clear to me if you were under the influence or impaired when the murder was committed, though you were using marijuana. And I find this as a mixed factor, but generally a mitigating factor. And then going to the level of maturity of you, Mr. Goodale, again, I think this is a mitigating factor based on the evidence presented. While you were older than Mr. Miller, and it was clear to me that you were not more mature than him, and that Mr. Miller was far more sinister in his planning and the execution of this crime. Both the United States Supreme Court and the Iowa Supreme Court have held that juveniles are constitutionally different from adults for the purposes of sentencing, and that's Miller versus Alabama and State versus Sweet, 879 Northwest 2D 811. That's an Iowa 2016 case. Mr. Goodale, you do not fully appreciate the consequences of your actions, but the analysis of maturity does not end there. While you were naive and immature, you aided Mr. Miller in murdering Nohema Graber. As everybody talked about, you knew the difference between right and wrong. You were a bright student and still are a bright individual. And you could have stopped this from happening, and you know that. And that's probably going to be the hardest thing for you to live with. Regarding the next factor, which is the intellectual and mental capacity of the defendant, I think this is a mitigating factor. Your youth and lack of fully formed brain limited your capacity to appreciate the consequences of your acts. And while you were a very bright 16-and-a-half-year-old and without a history of violence, I do find that to be mitigating. with respect to the nature and the extent of any prior juvenile delinquency or criminal history, I think this is a mitigating factor because I don't, no evidence that to my knowledge there was a previous criminal history, and you are a good candidate for rehabilitation. And I think time will tell, but you'll be far more successful than Mr. Miller. The mental health history of the defendant, and I didn't know about this until I read Dr. Cunningham's report of an undiagnosed ADHD and marijuana abuse in that 72-page evaluation. And prior to the report, I was unaware that undiagnosed mental health may have affected this crime. But this was the first criminal offense you were adjudicated for, so I think that is a mitigating factor. The next factor, which is letter O, is the level of compulsion, duress, or influence exerted upon the defendant, but not to such extent as to constitute a defense. So this is a mitigating factor to the extent that co-defendant Willard Shaden Miller influenced you to commit this crime. However, you could have notified law enforcement anytime during the planning stages. Mr. Miller did not threaten you if you didn't assist him. You weren't protecting yourself in doing this. And certainly it's not a defense to assert peer pressure as why a defendant commits first-degree murder. So while there's mitigation in this factor, there's also some aggravation as well. Letter P is the likelihood of the commission of further offenses by the defendant. And while there's no precise algorithm in determining whether you're going to commit any further offenses, Mr. Goodale, when you're released from incarceration, I do hope that you'll have time to reflect on your actions and grow as a person in prison, and I don't think there will be any other choice for you. And I said earlier, you're a good candidate for rehabilitation, and you appear generally remorseful for this terrible act, which is refreshing compared to the last sentencing, though it's just brutal for everybody to have to hear about this again. It really is, for everybody. Q is the chronological age of the defendant and the features of youth, including immaturity, impetuosity, and the failure to appreciate risks and consequences. This is a mitigating factor, that you were a minor when you committed this crime. The law treats you as an adult for the prosecution, but I am to consider your immaturity and failure to appreciate risks and consequences in determining your appropriate sentence. You didn't appreciate the consequences of your actions, but that does not bring Nohema Graber back here. And your age and remorse are actually, I thought they would be less a comfort to Ms. Graber's family, but it appears that it is of some comfort, at least to some. With regard to the family and home environment, with your circumstances, Mr. Goodale, and again, before this week, I didn't really know much about that. Certainly your home life was not the same since your mother left. While you have a complicated relationship with your father, he does care for you, and so do your siblings. Your home life may have been atypical, but you were not a troublemaker prior to the tragic events of November 2nd, 2021. I find this to be a mitigating factor. Letter S is the circumstances of the murder, including the extent the defendant's participation in the conduct and way familial and peer pressure may have affected the defendant. This is a mitigating factor to the extent Mr. Miller was the driving force behind the murder of Ms. Graber. But as I said earlier, Mr. Miller couldn't have done this without you, Mr. Goodale. There's no family influence on the murder. In a perverse way, you did feel peer pressure. But this was not cheating on a math test. This was the premeditated murder of a human being because Mr. Miller did not like his grade. Letter T has me consider the competencies associated with youth, including but not limited to the defendant's inability to deal with peace officers or the prosecution or the defendant's incapacity to assist the defense attorney and defendant's defense. This is a mitigating factor due to your lack of prior contact to law enforcement. And I will say that you were represented by experienced and talented attorneys who zealously advocated for your rights. Say the statement about the state just to keep it fair, but in considering that factor, certainly you had the benefit of excellent legal representation. The possibility of rehabilitation is a significant mitigating factor. You're a very good candidate for rehabilitation. While incarcerated, you'll be able to take advantage of the programming and education in the Iowa prison systems. When paroled, hopefully you have the skills to be a productive and law-abiding member of society. Based on the record of this case and of the record of Mr. Miller's case, because I learned somewhat about you in that case as well, and then the evidence presented on your behalf here and at other hearings. Letter V, is any information considered relevant by the sentencing court? And as I've stated, the U.S. and Iowa Constitution treats juveniles differently than adults in sentencing. I think this was mentioned earlier, but if you had helped Mr. Miller 18 months later, you'd be in prison for the rest of your life. So hope that is not lost either. I believe the bedrock of our criminal justice system remains the same, and that's deterrence and rehabilitation. I've considered your youth and developing brain, along with your intent and actions, which I think were cruel. In State versus Majors, which is a 2020 Iowa Supreme Court case, 940 Northwest 2nd, 372, Iowa Supreme Court Justice Waterman wrote that, quote, our earlier opinions have been criticized for running the risk of making it difficult, if not practically impossible, for a sentencing judge to ever impose a minimum term of incarceration. Yet, as we indicated in Roby, mandatory minimum sentences are permissible. While there is a presumption against mandatory terms of incarceration for juvenile offenders, we have expressly upheld, even commanded, their use if the court concludes that sentence is warranted after consideration of the factors. And Mr. Goodale, I believe because sentencing judges are in a unique position to deter homicidal and other violent behavior, while it may seem natural for a judge from Iowa to punt, in this case to the parole board, I don't think the parole board is adequate in its function that I have and the obligation and the oath that I take to protect the community. I believe judges at the district court level and the trial court level are much better positioned to order criminal sentences than the parole board. Court finds, based on the nature and circumstances of this offense, along with the 25 required factors I'm required to consider in sentencing a juvenile for first-degree murder, the defendants shall be sentenced to life with the possibility of parole after 25 years. This sentence is permissible under current Iowa law. The presumption against mandatory minimum sentences has been rebutted by the nature of circumstances of this case. And it represents the appropriate time of incarceration based on the defendant's premeditated murder. Count 2 of this case will be dismissed pursuant to plea agreement. Mr. Goodale, do you agree to pay the dismissal costs on the conspiracy charge? The Iowa Medical and Classification Center in Oakdale is designated as a reception center to which you're to be delivered by the Sheriff of Jefferson County or his designee. Again, you're given all credit for time served on this charge, including any juvenile detention center time. You do have the right to appeal your guilty plea. Your attorney must file a written notice within 30 days, and a plea of guilty is subject to a showing of good cause pursuant to Iowa Code Section 81429, and then the appellate courts will determine whether your application is granted. If you're just appealing the sentence I've just imposed and not the guilty plea, your attorneys must file that notice of appeal within 30 days, serve the written notice of that appeal upon the county attorney, and file the same with the clerk of court, together with evidence of such service upon the county attorney, and you must promptly mail or deliver an informational copy to the Iowa Attorney General. The service and the filing of a written notice of the appeal in the time and manner just specified is jurisdictional, and a failure to comply with such requirement shall be deemed a voluntary waiver by you of your right to appeal. You may be entitled to court-appointed counsel to represent you on an appeal, Mr. Goodale, in preparation of a transcript of the proceedings that we've had in this court at state expense. Judgment accordingly, minimus accordingly, bond and appeal is hereby fixed the amount, no bond. Counsel, do we need to make a record on anything else?
Nothing else I can think of. There you are.
Wish you luck, Mr. Goodale, and I hope everybody else in this room can heal as well. We'll close the record.
That means that person is going to be sitting behind bars until time for court, or in this case, this young man is not getting out until time for his parole hearing in 25 years. So no, he's not gonna be bonded out. But as for Jeremy Goodale, if he is as remorseful as he claimed to be, we'll know soon enough in 25 years. But as I like to say, that's justice. All right, let's see what I got up on the docket now. Oh, here's another look at the at Tiffanie Lucas. Hang on, guys. Let me pull her face up. Don't understand. I thought bond was good until sentencing. Does it get returned? I'm not totally sure, but I can look it up now. But I do believe that depends on the jurisdiction. All right, Let's see. All right, ladies and gentlemen, you're looking at the mugshot of Tiffanie Lucas. Here's why. I may have mentioned this the first time I posted this. 2 children were killed in a shooting Wednesday morning in Bullitt County. The Bullitt County Sheriff's Office says it responded to reports of a shooting at 213 Bentwood Drive around 11:07 a.m. that Wednesday. When police arrived, they located 2 children with gunshot wounds. Both children were transported to Norton Children's Hospital in critical condition. Around 2:50 p.m., police provided an update saying both children died from their injuries. Officials said the children were 6 and 9 years old. 32-year-old Tiffanie Lucas, who was the mother of the victims, was arrested and charged with 2 counts of murder. This is the follow-up article now, courtesy of the New York Post. Kentucky woman charged with 2 counts of murder after she allegedly shot her children ages 6 and 9 to death in their home. Deputies responded to a report of a shooting at Tiffanie Lucas's Shepherdsville house around 11 o'clock. Found her children suffering from gunshot wounds. That's according to a statement from the Bullitt County Sheriff's Office. Siblings were rushed to a Louisville hospital where they died, according to police. 32-year-old Lucas was taken to Bullitt County Jail and charged with 2 counts of murder. A neighbor who quote, felt something was off, found the children covered in blood in a bedroom next to a gun on the bed. That's according to the arrest report. Another neighbor told news outlet WLKY as she was shocked by the news after seeing the kids just days before at a bus stop. It makes me sick just thinking of any kid getting hurt or possibly losing their life. It's just devastating, she told the outlet. But there were no other details released at that point. But then I got another follow-up on that saying, this is courtesy of our friends at Court TV, Tiffanie Lucas was charged with murdering her 2 children, will remain in jail after the judge kept her bond at $2 million at her first court appearance. Charged with the shooting deaths of her 2 sons, 6-year-old Maurice Baker Jr. and 9-year-old Jaden Howard. Police say a neighbor found them brutally shot inside their home. Both boys were rushed with a police escort to Norton Children's Hospital in downtown Louisville, where they later died from their injuries. At Tuesday's hearing, Lucas entered the Bullitt County Courthouse in handcuffs wearing an orange jumpsuit. Bullitt County Detective Richard Beal was the only witness to testify at Tuesday's hearing about statements Lucas made after the shooting. I asked Miss Lucas if she meant to hurt her children, Beal said, and she indicated it was an accident. Beal said she told him that no one else had been in her home that day and that she left the gun in the bedroom. Beal said Lucas made other comments to him about the shooting, such as, "I'm in such a bad spot. I'm so stupid. And I would never do anything like this unless someone manipulated me." Prior to her first appearance, the judge had appointed a public defender to Lucas and set the bond at $2 million. Let's see what we got here. Baby Kisses says, "Me too, 6 and 9. That many years and do that." Yeah. That I don't blame you for being upset and heartbroken too, because what could a 6 and 9-year-old child do to make you want to kill him? We preach about this all the time. I'm here, not just here, Bethea'S Byte Reloaded, but other channels too. And we say the same exact thing. What could a child have done to make you want to kill said child? It amazes me. It just amazes me how the people that are supposed to take care of their children are doing anything but. Back to the Justice Serve file we go. We're going to Wisconsin, ladies and gentlemen. A jury finds Jessy Kurczewski guilty of killing her friend with eye drops. This is the verdict in the eye drops murder trial. Juries returned a guilty verdict in the homicide trial of Jessy Kurczewski, a Franklin woman accused of killing a family friend by poisoning her with eye drops. The jury deliberated for nearly 11 hours beginning Monday before a verdict was entered just before 1 o'clock on Tuesday afternoon, ending a trial that spanned 3 weeks. Kurczewski, age 39, wept openly as Judge Jennifer Dorough read through the guilty counts, 1 of first-degree intentional homicide and 2 of felony theft. Before I go on further with this article, I don't have it up. Hold on, guys. I am so sorry. I'm jumping ahead of myself. There we go. Here's our weepy defendant. As I started to say, if you heard the name Jennifer Dorough before and you're trying to place where you may have heard it, let me help you out. Remember the Wisconsin Christmas parade where the guy that had ran through and killed many people and injured many people? Then had enough nerve to defend him, to represent himself in court. Yeah, that judge presided over that case too. Let's see. 1 of first-degree intentional homicide, 1 of 2 of felony theft. Prosecutors accused her of killing 61-year-old Lynn Herman 5 years ago. Kurczewski was Herman's caregiver and one of only 2 people named in Herman's will. Prosecutors say the alleged crime was motivated by greed, claiming Kurczewski defrauded Herman out of more than $200,000. The defendant betrayed Lynn out of greed. This case highlighted the financial vulnerability of the victim and what a person will do to get what they want, said Deputy District Attorney Abby Nicoli, following the verdict. While convicting Kurczewski of theft, the jury agreed on lower felony charges. On each of the 2 counts, they decided the theft was more than $10,000, but less than $100,000. Anthony Pazza, who says he's known Herman all his entire life, wiped tears from his eyes when the verdict was read. When I learned of Lynn's passing, he said, I immediately knew something was awry and not reality. I thank God every day for the detectives and the DA that represented the case. Justice has been served. Rest in peace, my lovely Auntie Lynn. The defense did not speak after the verdict. Throughout the trial, defense attorney Donna Kushler argued that Kurczewski was like a daughter to Herman. She said Herman knew Kurczewski was using her money, and she took her own life while sick and depressed. When somebody takes too many pills, the combination together can create exactly what happened here, the Kukler said in her closing remarks. Everyone at the scene concluded it was suicide. Ladies and gentlemen, it was a suicide. It looked like a suicide. Sentencing is scheduled for December 7th. Kurczewski faces a mandatory life sentence on the homicide conviction. She also faces an additional 10 years combined for felony theft counts. Wow. And Baby Kisses giving me a case to flash back upon. An old lady named Dorothea Puente, a serial killer, had a boarding house in California, would get homeless on disability, keep their checks, and get people to dig holes in the yard for plants. That's something to think about. As for plants and trees at night, through through them and cover them up. She was a big donor for organizations. There was a good movie on it, but not sure it's on YouTube. I can root around for it and bring that back up when it comes time for Kurczewski's sentencing when that time comes. I was going to say that I was going to say this as a little bit of speculation on my part. The defense attorney is swearing that what happened with Lynn Herndon was a suicide. It looked like suicide. Well, here's a thought. Let's see. Yeah, this was in California. She was known as the Visine killer. Yeah. Well, this might be a copycat of that too. I'm thinking this. The defense attorney said that it was a suicide. It looked like a suicide. Okay. I'll play devil's advocate, but not in the way that the defense is going to look at it. It looked like a suicide. Okay, here's something to think about. What if Kurczewski poisoned Lynn Herndon and then staged the body to make it look like a suicide? Think about it. Talk about having the means, the motive, and the opportunity. She knew why. She knew why she wanted to do it. She knew how she wanted it done. The only thing she got wrong, and this is me playing criminal mind here, the only thing she got wrong was making sure it never traced back to her. And what was it all about at the very end? Baby Kisses summed it up perfectly. Money, money, money. In the immortal words of Vince McMahon, it's all about the money. Apparently, I guess they never they still don't believe in that old adage, crime doesn't pay. They don't believe it at all. Next. Now last week I covered the hold on, let me check Baby Kisses because she's got a lot to say and I love it. I don't know how people can do it. I don't either. Last week I covered the verdict in the Charlie Adelson murder trial. Charlie Adelson was on trial in the murder of his ex-brother-in-law Dan Markle, right? Found guilty. Well, guess what? Mama is wanted to flee from the United States, and she got busted. Could it be that Mama had a little hand in this too? Let's dig in. In an interview on Tuesday afternoon, Leon County State Attorney Jack Campbell revealed that Donna Adelson was arrested on a jetway at Miami International Airport while trying to leave the country. Court documents indicate that before her arrest, Donna spoke to her son about getting her affairs in order and leaving the country after he was convicted in a murder-for-hire plot. Donna Adelson was arrested on an out-of-country warrant on November 13th after purchasing tickets to Vietnam. She's charged with first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. Donna's son, Charlie Adelson, was convicted on the same charges last week in the murder of FSU law professor Dan Markle. In a probable cause affidavit obtained by Court TV, which I will show you all in just moments, prosecutors say that after her son's conviction, Donna had multiple phone calls with Charlie in which she told him she is, quote, is getting her things in order, creating trusts, and making sure her grandchildren are taken care of, end quote. Prosecutors argued in court that Charlie's trial, that part of the motivation behind killing Markle was access to his two children with Donna's daughter, Wendy. The couple had gone through an acrimonious divorce, and the court would not allow Wendy to move to South Florida from Tallahassee to be closer to Donna and the rest of her family. Campbell told Court TV that Donna was taken into custody at the airport, where she had arrived with her husband after purchasing plane tickets to Vietnam. Prosecutors did not specify whether the tickets were round trip or one way, but said that the tickets purchased on November 7th to depart November 13th would have taken the couple to Asia after a stop in Dubai. Now, one moment, please. Let me pull up the link to the yeah, here we go. This is what I was looking for. Yep. All right, give it a moment to load up, ladies and gentlemen. But what you're about to see here is a probable cause affidavit. All right. See here that the affidavit sets probable cause to believe that Cifrino Garcia and Luis Rivera murdered Florida State University Law School professor Nan Markle, and the murder was arranged through Catherine Magbanua, Charles Adelson, and Donna Adelson in violation of Florida statutes murder per chapter 782. And all this in 24 pages. PSA and the arrest warrant that follows it. I believe that's near the end. Yep. All I know is All I'm saying is like in the last case we've talked about. There's only a few things that drives people to murder in cases like this. One is custody of the children. The other, we just mentioned it, money. Greed. Oh my, wow. Okay, let's see. Let me see. Always studying and listening. I just love the way you cover these cases. I do my best, Elizabeth. I do my best. Thank you for the compliment, though. Yes, they did. Yes, they did kill the husband. Was already killed, and they just mentioned it in the PCA that Sigfredo Garcia and Luis Rivera were the ones who actually did the job, but it was arranged by. If I can pull that PCA back up again. It was arranged by Catherine Magbanua, Charlie Adelson, and Donna Adelson. Money, definitely. Custody of the children, definitely. So basically, it's all or nothing in a lot of these murder cases. You're right. It's a family affair. So if it's a family affair, I'm gonna go ahead and put on my prognosticator's hat real quick, and I'm seeing in the future a 3-week trial in which at the very end Donna Adelson will be found guilty on the same 3 counts her son was just convicted of. But that's just my prediction. All right. Back to the docket, and we've got another story about a beating death. Oh, let's see. First, Miss Liz, what do you say here? I'm kind of shocked. I'm kind of both shocked and not shocked that so many people had a hand in this, if that makes any sense. This kind of stuff. It should shock you over the fact that they did it, but at the same time, it shouldn't shock you because of that MMO. They have the means, they have a motive, and they have an opportunity. And part of it is the Adelsons didn't want to get their hands dirty. So if you want it done, hire a hitman or 2. If you want it done right, do it yourself. Again, that's criminal mind thinking. Now, we got another story of a beating death here. I am pulling this up. All right. We have 4 of 8 teens to be tried as adults for a high school student's beating death. Jonathan Lewis Jr. was punched, kicked, and stomped after an after-school fight broke out in an alleyway near a Las Vegas high school campus over a pair of stolen wireless headphones and a marijuana vape pen. That's according to Las Vegas Metro Police Department. Lieutenant Jason Johansson said the initial 911 calls on November 1st came in after someone found Jonathan bleeding and unconscious. Then brought him over to Rancho High School, where officials said staff members immediately rendered aid until first responders arrived on the scene. He was transported to University Medical Center for treatment, where police say doctors quickly determined his injuries were not survivable. Police were notified a week later on November 7th that the teen was taken off life support and his organs would be donated. A spokesperson for the Clark County Coroner's Office confirmed Lewis died as a result of multiple blunt force injuries, and the teen's death was ruled a homicide. At the first court appearance, sources say 8 teens between the ages of 13 and 17 appeared before a judge Wednesday at the Clark County Courthouse, where prosecutors notified the judge that they planned to charge 4 of the 8 as adults for Lewis Jr.'s murder. The other 4 teens are under the age of 16. A juvenile court hearing will determine whether those 4 will be tried as adults as well. On Wednesday, Las Vegas police released new images as 2 more teenagers who are wanted in connection with the homicide investigation. Multiple videos of the altercation was shared widely on social media, which police used to identify students who've since been arrested for open murder. Lieutenant Johansson said of these videos that many people have seen it. It's very graphic and, in my opinion, devoid of humanity. Rancho High School students were in shock when they spoke with Scripps News Las Vegas following the attack, saying they could not believe what happened to one of their classmates. It's just very unnecessary to take away his life, one student said. And for all those people to jump in over something so simple, it's kind of sad. Police are asking anyone with information about the 2 subjects who remain at large to call Metro's homicide section or Crime Stoppers. The homicide section you can be reached at 702-828-3521 or emailing homicide@lvmpd.com. Those anonymous tips can be made through Crime Stoppers at 702-385-5555, or you can go online at crimestoppersofnv.com. Just letting you know, that's letting you know that this investigation is still ongoing. Yeah, beat him to death. And hopefully, once it's all sorted out and these teens go to court, justice will be done. Justice will be served. And all 8 of these teens will get exactly what they deserve. Oh. Okay. Next up on the docket. Oh, wait. One second. Liz Ross says almost all school fights and violence in school is posted on social media now. It's sad that it's getting worse, but they are getting caught. Absolutely, they're getting caught. Baby Kisses adds, a girl from Wisconsin came to Kansas with my sister. She slept with a married guy. His 16-year-old daughter did the same to me. Beat me in a circle. I was 12 and had no idea who she was until the next year. Dang. That's 8 up. Okay. On the docket right now is the sentencing of Timothy Dunn Ferriter. Now, what I'm about to read and what you're about to see, you get the chance to answer the question, is this justice served? Let me begin with the article first. At a sentencing hearing Thursday, a Florida man convicted of aggravated child abuse, false imprisonment, and child neglect for locking his adopted son in an 8x8 box in a family garage was sentenced to 60 months in prison. Excuse me. My notepad just popped up. Sorry. Tim Ferriter faced up to 4 decades in prison for keeping the teen boy in a windowless room for extended periods. The child had no control over lights or air conditioning and was forced to use a bucket for a toilet. An emotional Ferriter addressed the court at his sentencing, telling the court, "I have failed." The victim in the case also testified at the sentencing, telling his father he still loved him. Ferriter, age 48, opted not to testify on his own behalf and remained stoic throughout the trial, even as he was found guilty of all charges against him. However, he shook uncontrollably at a hearing during which he asked to be released from jail prior to sentencing. The boy, publicly known as RF to protect his identity, is now 16. He testified at trial stating that being locked up was dehumanizing and like genocide. RF's sister was also a witness and told the jury that she witnessed Ferriter abuse her brother. Ferriter's defense team tried to convince the jury that their client had simply made bad parenting choices in trying to control his son's severe behavioral issues, and that he never meant to hurt RF. In the weeks leading up to the trial, Ferriter rejected a plea deal offered by the state that included a 2-year prison sentence followed by 5 years probation. That deal was contingent upon Ferriter's wife, Tracy Ferriter, accepting the same deal. Tracy will face a separate trial. The date has not been set yet. And it is not yet clear if she will be offered a plea deal. Ferriter, who was out on bond for the duration of his trial, was immediately remanded to the custody of the Palm Beach County Sheriff's Department upon conviction. The judge sentenced Ferriter to 5 years in prison and 5 years probation, the first 2 years of which he will not be allowed to have any contact with the older 3 children unless the children desire it. Ferriter was also ordered to complete an anger management class, a parenting course, and get a mental evaluation. Okay, let's go to this. Baby Kiss is 60 months. Yeah, 60 months, 5 years. 5 years, yeah, that's all he got. You were hoping for 10 more years? Funny you mentioned that, Liz. So was the prosecutors. OMG, no wonder he acted up. Yeah. That's unreal. He was out on bond for torture of a child. Which is why I'm asking now. You be honest with yourself, and I want you all to be honest with yourself. Okay. I'm just getting everything set up. I'll tell you what I would have done after I show you this piece of video showing you Tim Ferriter, quote unquote, showing his remorse for what he did. Ladies and gentlemen, I'm taking you straight to Court TV. Our good friend Julia Janae, who is covering this case in Florida.
Will be able to have supervised interaction with that younger son, but he will not have any say in the discipline of that child. So really hard day all around for everyone there in the courtroom.
Absolutely. This was a tough case, but again, it gets back to that headline. He locked his son in a box, and I don't think anyone can get over that or beyond that or really comprehend or understand that. So, as you always do, Julie Janae, you're there on the ground, and for folks coming home tonight, you can sort of dissect the day and present to us three of the big moments aside from the judge handing down the sentence. What do you have for us first?
The biggest moment, Vinny, was Timothy Ferriter speaking in court. We haven't heard him share his side from his own voice. He's had his attorney speaking on his behalf. He didn't speak at his trial. So there was a question of whether or not he was going to say anything to the judge today, and speak he did. The audio wasn't great in terms of the microphone that he used, but inside the courtroom, we could hear him clearly. And his words were strong, and there was a level of care in them. He spoke directly to each member of his family, each child by name, gave them almost this goodbye message. And that's when I was seeing that emotion from his family members, emotion from his wife sitting behind him that he addressed as well. Here was his message to his son.
Mom, I love you. Your mama loves you. We're all very sorry for everything. Everything we have gone through, and everything we continue to go through. I am empathetic to where you are placed now. I did all that I could to help you avoid that. As your father, I wish I could be by your side now and stand strong with you. I thank you, Ronan, for your honesty and courage when you spoke of mercy a few weeks back. Ronan, you were my first boy.
Okay, that was the first question I was going to ask. Did anybody see any kind of remorse? Elizabeth Ross says, I did not. Neither did I. Not in the least. Neither did Baby Kisses. Now, as far as from what I can tell you, as far as I don't know whether I stopped it at a point, but maybe I should have taken this a little bit further. But let's see.
There were times when Timothy Ferriter broke down. He had to stop himself when he spoke about his kids. So he really shared this father's love to the court. And you wonder how that may have come across to a jury if he had been able to speak in the way he did today. But Vinny, as I mentioned, his son was there with people who had their arms around him, arms on his back while he was listening. And there were times he looked down on the ground, had his entire body keeled over. But then there were other times that I saw him just taking off his glasses and wiping away tears. So there were just poignant moments throughout this sentencing.
Julia, I think you're right on here, because at the trial, I remember as we're watching this, and he didn't take the stand and he didn't speak. He didn't humanize himself. He was like this monster that was described, and we heard the recordings and we saw this video of him putting the camera in the box. I mean, all of this, to me, there was no sense of, well, where's the love? Where is his humanity? Where is his fatherhood? That's what I think the jury would have needed to hear and understand, to try to understand his explanation, but it didn't happen.
I stopped that there I stopped that there to agree with my man 50 grand Vinny Politan, because he said something that I've heard from the Honorable Judge Greg Mathis in one case in his on his court show. He said he was all about tough love, but where's the love? From the video evidence we've seen in this case, all we've seen was toughness. I didn't see any kind of love in that. And if anybody did though, let me know, because I may need a brand new pair of glasses, and I actually do. Anyway, let's go ahead and set this for the record right now. 5 years. 5 years of probation. Credit for time served. Plus he's ordered to, if I'm pulling this back right, he has to complete an anger management class, complete a parenting course, and get a mental evaluation. And the first 2 years of his probation, unless the older children desires to, he can have no contact with them. I know I've got Baby Kisses. I know I've got Elizabeth Ross in the chat, and I'm gonna go ahead and extend the invite, because I mean it's one thing to hear from you from you both in chat, and I appreciate it. But I would love it more if I could get you on an open panel. This is the case I've been waiting. This is the case I've been waiting Good to talk about. So if you'd like to jump up here, if you'd like to jump on, you got the link. You can copy it into a new browser window, browser tab. You can click on it. I would love to actually hear from you and answer the question: 5 years in prison, 5 years on probation, is this justice served for someone convicted of child abuse, child neglect, and false imprisonment? Oh, let's see. Liz Ross says, I have a very strong feeling that if I was raised in this controlling of a manner, I would rebel every hour of every day. Bet. And Baby Kisses, as far as getting on the panel, voice isn't good enough, I'd end up with asthma. Oh, that's messed up. And but she's urging Elizabeth to come on. Hey, I would love to have you. I would love to have you, because this honestly, to me, it's not justice. I mean, you're constantly locking this boy in a hot box. No window. There's air conditioning he can't touch. He can't move around freely like he wants to. He's confined. And he's in there for what? Some 16, 18 hours a day? Where's the justice in that? Too much going on in the house because my son has a friend over, and they I understand. Okay. All right. So much for the invitation. I tried. Let me let you in on what I do. He's convicted on, let me remind you again, he's convicted on child abuse, child neglect, and false imprisonment, right? The maximum is 40 years. He'd get the max if I was the judge. Let's see. Baby Kiss says she raised 9 and kids, my stepkids, 8 ADHD. One nephew had it. They got along great, but they are definitely their own persons. That's good. That's good to know. No, better to have their own identity. Yeah, 5 years. Baby Kisses, I'm about to break down what I would have done. I would have given Tim Ferriter 40 years. All of it. All 40. No chance parole. No chance to appeal. No probation. He would have to do. He would literally have to do the entire 40. Contact with his kids. Forget it. Those kids deserve some kind of freedom, and this would be it. Oh, as far as Tracy Ferriter goes, I'm gonna use a quote from a story I brought last week, and this is and Tracy Ferriter. I hope you hear this as the voice of justice whispering in your ear. That voice telling you this: I'm coming for you next. Elizabeth Ross leans toward the max when children are involved. That's me. That's me. When children are involved, I tend to lean toward maximum sentence, and I don't just lean on it. I stand on that mount. I stand on that rock. You hurt a child, I want you to get you hurt a child, I'm praying you get the maximum sentence. Period. And as far as Tim Ferriter's I don't believe he's sorry for a minute. Let's see next. Oh, let's see. Famous case: Skinner box, psychologist in Freud time. Locked his baby girl Anna in a small wooden box every day, all day. Had schizophrenia from it. See what I mean? It's amazing. It absolutely amazes me. Next on the docket, another trial, another verdict, another sentencing. This time we're gonna get it all in one. This time we'll get it all in one shot. Kaitlin Armstrong has been found guilty of murdering elite cyclist Anna Mariah Mo Wilson. The penalty phase began immediately, and the same jury sentenced her to 90 years in prison. 35-year-old Armstrong was apparently in the throes of a jealous rage on May 11, 2022, when she fired bullets into Wilson's head and heart. Armstrong was allegedly furious that her boyfriend, professional cyclist Colin Strickland, had secretly gone out on a date with 25-year-old Wilson. A 43-day manhunt for Armstrong ensued when she skipped town after being questioned and released by police about why her 2012 Jeep Grand Cherokee was caught on surveillance video near the scene of the murder. Police didn't have enough evidence to make an arrest, but Armstrong proceeded to sell her vehicle and hop on a plane. She went from Austin to Houston to New York and eventually landed in Costa Rica. Armstrong was captured in Costa Rica in July 2022. She had apparently undergone plastic surgery and dyed her hair. She was lying low at a hostel and had been using her sister's passport. Armstrong was extradited back to the United States, where she pled not guilty to the murder charge. Bail was set at $3.5 million, and she has remained in custody ever since. In addition to that murder charge, Armstrong also faced a felony charge of escape causing bodily injury after she tried to escape from guards while at a doctor's appointment in Austin on October 11. According to the affidavit, she took off while exiting the doctor's office and made it about a mile on foot before being apprehended. Police believe the escape attempt was premeditated. They say Armstrong spent months exercising vigorously. She complained of an injury that required visiting a doctor outside prison walls, and the medical request ensured she would not be wearing leg restraints during her appointment. On the Monday before her trial began, Judge Kennedy ruled that evidence in Armstrong's alleged attempted escape would not be allowed during the murder trial. At the time of her death, Wilson was in Austin to compete in the 150-mile gravel locos bicycle race. Wilson, whose career was just taking off, had just reached top levels in both gravel and mountain biking in the United States. Investigators believe Wilson had unknowingly gotten caught up in a love triangle. She had dated Strickland during a brief period of time when he and Armstrong were on a break. Armstrong and Strickland reconciled soon after, but according to an arrest affidavit, Armstrong became furious when she found out about the romance. Armstrong faced up to a life sentence, up to life in prison at the sentencing. The jury sentenced her to 90 years in prison as well as a $10,000 fine. Now, excuse me. That's the one I meant to hit. Was she a psych professor? I believe she was. All I can say is that as far as that sentence compared to the Tim Ferriter sentence where the max was where the max was out there, what the jury did in Kaitlin Armstrong's case, yeah, that's justice. 90 years behind bars for murder, yeah. No. This is Kaitlin Armstrong. Yeah, Kaitlin Armstrong will be sentenced to 90 years behind bars. And yeah, you're right. 90 years, yeah, wash those hands. Yeah, she's pretty much done. Stick a fork in her. And next on the docket, oh, we got another one. This is another one. Like I always say, we got another one we can file under justice served. This is in the strangled girlfriend murder trial. We had first. I've only taken these stories down in this one when the right when the trial first started and when it first ended. So, a start. It says the jury selection began Monday for a man accused of killing his girlfriend, whose body was later found frozen in a ditch. Ivan Sand Brammer was charged with second-degree murder, tampering with a corpse, and theft in the death of Eileen Gowan. 60-year-old Gowan was last seen with Brammer, with whom she was in an on-again, off-again relationship on February 13, 2023. Gowan was reported missing on February 15th by her daughter, Nicole Shipper. Nicole told police when she reported her mother's disappearance that her mother had in her possession a personal safe containing $1,200. After days of searching, her body was found on February 26th in a ditch, partially frozen. Gowan's clothing was intact, but her purse and safe were gone. While temperatures had gone above freezing the day she disappeared, they dropped soon after, and investigators say they believe Gowan was in the ditch the 11 days she was missing. Investigators quickly focused their attention on Brammer, whose relationship with the victim was described by friends and family as volatile, with as much verbal fighting and alcohol involved. Two witnesses who spoke to police said that before her disappearance, Gowan had been kicked out of the apartment she shared with Brammer, and that Brammer had been holding her personal safe, which contained $1,500, until she paid him $300. Police stated that February 15th, Brammer deposited $1,500 into his bank account. In an affidavit obtained by Court TV, detectives say they interviewed Brammer 4 times between February 15th and 24th. While Brammer initially told officers that he had picked Gowan up at 8:30 a.m. and took her to a house where she was staying with a friend, he quickly changed his story. Detectives said this was proven to be a false statement, and each interview after, when presented with inaccuracies in previous statements, Brammer would change his story to conform to the facts presented. On February 25th, the day after his last interview with police and the day before Gowan's body was found, Brammer sold his truck to a salvage yard. It was crushed and shredded the same day. When police looked at video from city and private cameras on February 13th, they began to put together a timeline that showed when Gowan may have died. As you can see here on C830 to 928, she was seen walking, acting normally, and sitting upright in Brammer's truck. 1028, Brammer seen driving his truck, but detectives note something is different with the way Gowan is sitting or positioned in the truck. At multiple locations, it appears Gowan is awkwardly slumped in the passenger seat. 1056, police note that Gowan does not appear to have moved or changed position. 1106, Gowan is no longer visible in Brammer's truck. The initial autopsy revealed bruises, cuts, and scrapes to most of her body, as well as head injuries. None of the head injuries were believed to have been severe enough to cause her death. The medical examiner who conducted the autopsy said that due to the level of decomposition, they could not determine the cause or manner of death, which were both listed as unknown. Brammer was initially charged with tampering with the corpse and theft of $1,500, but prosecutors upgraded the charges after getting a second opinion on the cause and manner of Gowan's death. Dr. Baden, a doctor in New York, consulted on the case and offered his opinion that Gowan's cause of death was traumatic asphyxia due to neck compression, and the manner of death was homicide. Now that was on Monday. This is what I took down yesterday. A jury deliberated for less than 2 hours before returning a verdict for a man accused of killing his girlfriend, whose body was later found in a ditch. So instead of me just talking about it, why don't I just take you straight to the verdict itself? And if I can get right back to the yeah, here we go. I'm in that area right here. All right, there we go. I gotta hit that copyright disclaimer. That way I don't get in trouble with Court TV or anyone else that I use their videos with. All right. And now here's that verdict.
State of Iowa versus Ivan Samuel Brammer, case number FECR 171749. Reading of the jury's verdict. Count 1. For and verdict number 1, we the jury find the defendant Ivan Samuel Brammer guilty of murder in the second degree. As to count 2, we the jury find the defendant Ivan Samuel Brammer guilty of abuse of a corpse. Count 3, we the jury find the defendant Ivan Samuel Brammer guilty of theft and further find the value of the property taken by the defendant to be more than $1,500 but not more than $10,000. Each form of verdict properly signed by the foreperson. Please be seated.
Justice served? I tend to think so. And again, maybe you have a wholly different opinion on that. Moving onward in the docket, I got a case that almost froze me in my tracks. Next, so we'll go ahead and pull this up for you. A man accused of kidnapping a 9-year-old girl is also charged with rape. I'm not gonna I really don't want to sugarcoat this, but it's YouTube, so you know their deal. And no, I'm not gonna use that. I'm not gonna use the name of the fruit to cover up the word that's being used here. I mean, I'm for all intents and purposes, I'll just use the as much as okay, yeah, just say are. I'll do that. Thanks. Baby kisses with a great piece of advice. Appreciate. All right, you come back anytime. We're more than happy to have you. All right. A man accused of kidnapping a 9-year-old girl from a state park in upstate New York arred the child during the 2 days she was held hostage before her rescue, according to prosecutors on Friday. Craig N. Ross Jr. was initially charged with only first-degree kidnapping in the abduction of the girl on September 30th from Morose Lake State Park, located in the foothills of the Adirondack Mountains, about 35 miles north of Albany. A massive search in the rural area ended 2 days later when state police troopers and FBI SWAT team stormed a camper Ross was staying in. Rescuers found the girl in a cabinet. The break in the case had come after officers stationed at the girl's home saw someone drop a ransom note in the family's mailbox before dawn. State police matched fingerprints on the note to Ross, who was in a database because of a 1999 drunken driving case. An indictment made public Friday kept the kidnapping charge and added 4 counts of predatory SA against the child, along with charges of SA, assault, and endangering the welfare of a child. Ross pleaded not guilty in Saratoga County Court. A phone message seeking comment was made to his lawyer. District Attorney Karen Hagen told reporters afterward that the defendant committed a heinous offense against a young victim. We will hold him accountable and responsible, she said to WNYT-TV. The girl had been riding her bike around a campsite loop in the park with other children on a Saturday evening when she decided to ride around one more time by herself. Her parents became alarmed when she failed to return after about 15 minutes. An Amber Alert was issued the next morning, and more than 100 police, forest rangers, and civilians took part in a search that employed drones, bloodhounds, and an airboat. Troopers set up checkpoints on the winding rural roads around the park. Ross has been in jail without bail since his arrest. To which I say, good. I say good because for everything he's charged with, he doesn't deserve bail. He does not deserve bail. Keep him in there as long as possible. Bring him to trial, and then let the jury do what they do. Find him guilty, and then stick him in there for even longer. That's what I do. My sentiment exactly, Elizabeth. Just riding a bike and enjoying the day with a loser like this on the streets? No. That's another guy that deserves what he's got coming. And finally, on my last story on this docket. This one is calling for prosecutors in his case to be disqualified. Why? Let's dig in and find out, Rose, shall we? A man facing a potential death sentence in a murder-for-hire plot that killed a Microsoft executive in Florida has asked the judge to remove the prosecutors from his case. You Santos Escobar looking. Mario Fernandez Saldana was indicted in March on charges of first-degree murder. First off, let me stop real quick. I'm laughing because he looks like a wrestler I was watching last night. And I swear, from his facial features looks just like the guy. That's probably why you heard me called him a Santos Escobar looking, and I just stopped right there. Anyway, Mario Fernandez Saldana was indicted in March on charges of first-degree murder, conspiracy to commit murder, solicitation to commit a capital felony, and child abuse for the shooting death of Jared Bridegan. Bridegan was shot and killed on a quiet road in Jacksonville after dropping his 2 older children off at the home of his ex-wife and Saldana. Saldana and his wife, Shauna Gardner, who was previously married to the victim, both faced the death penalty if convicted. Gardner was recently extradited from Washington and has retained prominent attorney Jose Baez to represent her. Now, if the name Jose Baez rings any bells, then you already know. For those who don't, I'll give you one name: Casey Anthony. Did that ring your bells yet? In a motion filed on Wednesday, Saldana's attorney Jessy Dracer has asked for the 4th Judicial Circuit Office of the State Attorney to be disqualified from the case after they allegedly inappropriately accessed privileged information from their client's phone. Saldana's attorney alleges that when officers served a search warrant for his phone on February 6th, they inappropriately accessed messages between Saldana and Gardner, as well as messages between Saldana and his attorneys. I believe deep down it's just a stalling tactic. But I'm just gonna have to wait and see what becomes of it. And pretty much that's pretty much will wrap the whole thing up. That'll wrap up the entire day. But before I go, before I totally wrap this thing up, I mentioned at the start that I was in a very, very somber mood. And that is because I found out last night that one of our co-laborers in the YouTube true crime community had passed away last night. I want you all to take a look at this special woman here. She went by the handle Checking Convictions. Her mission was twofold, and she was strong in both of those aspects. She wanted to see the wrongfully convicted set free, and she wanted to see the missing returned home safe. Her dedication was unwavering. Now, I've seen her do her think tanks with one of my main guys here, Arctic Fox True Crime, and I know because of the bond they shared as advocates for the missing. He looked at her as a dear friend, and I looked at her as a dear friend to the true crime community. I was trying to gather the words as to what to say to honor this woman and to bring comfort to the family. And the only thing I could find with a modern translation to it is Psalms 23, because I've known this very piece of scripture to be a comfort to those suffering loss. For those of you who know the traditional, that's fine. But this is the version I have for those who do not. The Lord takes care of me like a shepherd takes care of his sheep. I have everything I need. He gives me a place to rest in green pastures. He leads me beside peaceful streams. He renews my strength. He guides me on right paths to show he is good. Even if I walk through a valley as dark as the grave, I will not be afraid of any danger, because you are with me. Your rod and your staff comfort me. You prepare a feast for me in the presence of my enemies. You honor me by anointing my head with oil. My cup overflows with blessings. Surely goodness and unfailing love will pursue me all the days of my life, and I will live in the house of the Lord forever. Linda, you will sorely be missed. I thank you with all my heart for your dedication, for your love, and for your strength. The battle is over now. You can rest now in the arms of the Father. We'll take it from here, and we'll do our best. I'm going to take this moment of silence before I say goodbye. Thank you. That's going to do it for this edition of Bethea'S Byte Reloaded. Thank you all so much for joining me. Thank you for watching this replay. And you'll know exactly how to follow me at the end of this video on Facebook, on X, here on YouTube, Instagram, TikTok, email. I would love to hear from all of you, as I always do. And I couldn't do this without all of you, which is why I'm so grateful. I want you to know, guys, I love you. I want you to take that love and I want you to pass it to everyone you come in contact with. And Elizabeth Ross is right. She had a ray of sunshine in her smile. I've noticed that when watching a Think Tanks with Arctic Fox. Anyway, like I said, I want you to take that love, spread it around, be good to yourself, be kind to yourself, love yourself, and do the same for others. You never know how much they need it. And hopefully, I'll see you back here next time for Bethea'S Byte Reloaded. More stories, more verdicts, more justice served. Until then, this is Ernest Bethea, the last outlaw. We'll do this again next time. Until then, you all know what to do. Bite this. Hey guys, this is the last outlaw saying thank you to all of you who watched this video and subscribe to Bethea'S Byte Reloaded, your drama-free true crime destination. I couldn't dream of doing this without you, so thank you. Did you enjoy this presentation? Are you looking to get more information on everything presented here? Are you looking to give more feedback on this presentation? Here's what you can do. Like this video. The more eyes on this video, the more this information is spread to others, which brings us a step closer to justice served. Share this video to your social media. Just like dropping a like, the more eyes on this video, the closer we get to justice served. Drop me a comment, whether it's on the topic or the presentation. I am open to all comments, whether it's a theory, a speculation, or a suggestion. I will respond to all. If you haven't subscribed yet, what are you waiting for? Hit the subscribe button to show your support of this little true crime engine, powered by you. Set the notification bell to all for future videos. Be sure to follow Bethea'S Byte Reloaded all over social media. At Bethea'S Byte Reloaded True Crime on Facebook. At EKB316 on X, formerly known as Twitter. At Bethea'S Byte Reloaded on YouTube. At EKB316 on Instagram. At King of Hearts 316 2021 on TikTok. You can drop me an email as well. The address is kingofhearts316_09 at outlook.com. This is your home for news without the drama, where your opinions matter, for lively debates, where your voice is heard, and above all else, justice served. This is Bethea'S Byte, and it's reloaded.